270 electoral votes. If you flip 3 bribe people and they're disqualified, it goes to the House of Representatives. And, you know, we could have had a situation where you have a Republican House of Representatives, the Democratic candidate won with 270, 3 bribed electors, the Republican House picks the Republican. That's a constitutional crisis like we've never seen. Or the worst scenario is we don't know. And the bribe elector is not found out, switches their votes, it's counted by Congress, and you have a swayed presidential election. So that's a really scary proposition. And I thought it got well understood by the court. And it's one of the reasons that I have a hard time seeing us not prevailing.
Well, thank you for that answer. We do have another question that's come in, and this is actually something that you know, our membership has talked about quite a bit. The National Popular Vote Compact. The question is, can you explain what that is and how all of that fits in or potentially could be impacted by the decision in the Baca case?
Jena, why don't you take this one?
Okay, Phil. Nice, easy one. The National Popular Vote. Okay, so National Popular Vote Compact is basically an agreement that says, and you pass it by state law. So a state would pass a law, and it basically says if enough states pass the same law, that's equivalent to enough electoral ballot votes to swing the election, then the presidential electors in those states will cast their ballot for whomever wins the national presidential vote. Would you add anything to that, Phil? I always explain this not as clearly as possible.
No. Here's the thing. We could be here for the whole time just going deep on this issue. So I think that's a fun explanation.
Okay, so that's the basis. So the basis of it is, okay, enough states pass a law that says their presidential electors will vote for the national vote. Then the law becomes in effect, and whoever wins the most votes nationwide for president wins the presidency. So Colorado passed this law in 2019. League of Women Voters supported it, I believe, and talked to everybody about it. In the law, basically, National Popular Compact is a law. So how the Supreme Court case relates is that the Supreme Court case is basically about whether state law can be enforced with presidential electors. The 10th Circuit said you cannot enforce state law because it's outside of the state's purview to enforce anything that has to do with presidential electors. So Phil and I disagree. That's what we're arguing. We're saying we can enforce state law. So it's related in the circumstances that National Popular Vote Compact is a state law. It's kind of a dormant state law right now, both because it's going to be on the ballot, and then it will still remain dormant until enough states opt in. But it would be a law just the same. So the question is, if someone, a presidential elector, would disregard that law, could we make sure that we replace that elector with someone who will follow the will of Colorado's voters or state law? Would you add anything, Phil?
Yeah, the one point I'll add is, because this came up a lot in argument, the question is, what constraints exist on a state's ability to remove electors? And we focused on some precedents that talked about plenary authority by the states, which means the states have broad discretion, and there are only a couple exceptions. For example, the Equal Protection Clause, you can't remove an elector because of her religion. Another one that's a pretty thorny area, which honestly, if I had more time, I would wish I had gotten deeper, is could a state violate the Presidential Qualifications Clause by adding qualifications to serve as president? For example, you can't vote for someone who's younger than 50 years old. The Presidential Qualifications Clause specifically said 35 years and older. If a state tried to raise that, it would be violating that clause. What else would violate that clause is an interesting question. The question that I think is implicit in here is, if states don't have broader authority, if they have, let's say, no authority at all to decide how electors would act, then I don't know how you'd enforce the National Popular Vote Compact.
Yeah. People, electors, by the way, one of the opposing counsel's argument is, like Phil mentioned, there hasn't been enforceability from the Supreme Court clearly laid into law, and the system has worked. So the counter argument is, well, you could have whatever your state law is, or national, if it's national popular vote or our current law, and people will just comply. And usually that's the truth with with most of our laws. Most people will comply with laws, and you have it there to guide action, and to make sure for the small percentage of people who don't comply that you have the ability to enforce. And by the way, there's a lot of laws that don't even have enforcement mechanisms, and people just follow them because that's how we decide. We decide we are a society that believes in rule of law, and that's how this works. So there is a chance, even if we would lose, everything would be okay. There's a good chance, but there's also the reality that we shouldn't be incentivizing a couple people that disenfranchise everybody else. And we should be worried about the undermining of our democracy, and we should protect our institutions. And that's what we're really trying to do.
If I could riff on that in a direction that's notable for this week, Chief Justice Roberts has shown a great awareness about the Supreme Court's institutional legitimacy and our constitutional system needing to have legitimacy. He ruled twice this week with Kagan, Ginsburg, Sotomayor, and Breyer, once involving Title VII and the rights of LGBTQ individuals not to be discriminated against, and just today with the Dreamers. I think that's an important point to note about, which is our Supreme Court is overseeing a legal system that helps the institutions of governance work, and people need to believe in those. People need to believe they're fair, and that's part of what's an issue in this case. If I could jump to Beth's question, because it's in the same ballpark here, mention that there's another way to reform the Electoral College other than national popular vote, which is, and by the way, Manny's question, what do you say to people who want to abolish the Electoral College entirely? I was talking to someone this week who said, ideal in reality, which is to say that I don't think the abolishment of 2/3 of the states agreeing to abolish the Electoral College is going to happen, which is why you see the national popular vote, and why you see another movement, which is encouraging states to go to this more proportional vote system, because that would be another way to, within the Electoral College, make it more democratic. We have a very delicate issue here, which is a collective action problem. Each state says, I'm better off winner take all because it encourages people to pay attention to me. Whereas if I do the proportional model, like Nebraska and Maine are the two that do it, I may get less attention as a result. So I haven't thought really hard about that particular reform. I will say we're going to see more and more discussions of these kinds, particularly if the popular vote is different than the Electoral College vote.
Well, thank you for walking us through that and sharing some thoughts on that. Secretary Griswold, anything to add there?
No, I think that's right. Another thing that came up on Phil, what is the provisions about adding qualifications to the presidency?
Yeah, so this is an important point, and if people listen to the argument, you would remember Neil Gorsuch pushed me really hard on this, and he asked me a couple of questions. He said, would a requirement that you had to release your taxes, and you have to say electors can only vote for someone whose taxes are released, would that be an additional requirement to be president, additional qualification, and violate the qualifications clause? And there's no case law on this. There's one important case involving congressional qualifications, which is the term limits case, but in the presidential qualifications, it's never been litigated before. So it would be up to me to develop my theory. And my theory was, well, that's plausibly a violation, and a court in California held it as such. So I tried to be less than definitive, but at least point them to that court case. And this issue was one that was debated in Colorado, and actually we gave the advice to a legislator, you might do something different. If you don't release your taxes, you're listed last on the ballot, because we thought that wouldn't violate the presidential qualifications clause, and it would be impactful, because being lower ballot position often can hurt you. So anyway, that was here nor there.
That's why, go ahead.
The other issue was, would a requirement you had to visit a state in order for an elector to be able to vote for you, would that violate the President's Qualifications Clause? And I said no, that would fall within the plenary authority of a state to add that.
So this is Tony, and I can't find my chat box. So I'm just wondering, Secretary Griswold, what kinds of things would you have to put in place if we were allowed to have a faithless elector system? What would you have to do? A lot more monitoring and reporting and things like that?
Well, that's the exact problem, Tony. So if we lose this case, we're not going to be able to do anything, or we're going to have to be really creative. So literally, it could be plausible that I'm overseeing the casting of the ballots for the president, and someone is bribed right in front of us in open air, and we cannot do anything. That's why I was working with Jeff Bridges this last legislative session to bring forward a bill making it a felony to bribe an elector, to make sure that's really clear. And that's one of the pieces of legislation that unfortunately was sidetracked because of COVID-19. But we are already working on the things that we would do if the unthinkable comes to pass, so that we have all of our options on the table going into the situation. But the entities that are best situated to control and mitigate against the electors disenfranchising Coloradans and Americans are actually the political parties, because the political parties appoint the electors. And being government officials, we have different duties. The First Amendment and First Amendment violations attached to us. So there are things that we cannot do in law because of First Amendment rights that the parties can do. So for example, a party could decide that an elector needs to post a bond, and that if they do not follow their oath to uphold, cast their ballot for whoever wins, they'll forfeit a lot of money. The electors, or the party could do a whole host of things with contract that we can't just do because we are government. And I also will say, Phil and I have chatted about this at length. Just depending on what circuit you are, affects the government's ability to respond. And I think we're in a little bit more a circuit that really contracts some of the things that we would be able to do otherwise in different circuits. So that's the fundamental issue, that we won't be able to do as much as we otherwise could. Which is the right course of action. If we know someone's bribed, the right course of action is to remove them. Anything short of that is just an affront to our democracy. So I really do hope that we win this case, and I am really confident that we will.
Jena, you might as well follow up a good question someone said. How do you become an elector?
So it's through the parties, right? And every state party is different. So for example, the Republican Party in Colorado, their executive committee appoints the electors. The Democratic Party in Colorado, people run to become an elector. So the parties can switch how they do that. They can add qualifications, they can add punitive contractual stipulations, and it's really a mechanism of the parties, and that's why they're best situated to be able to help with the outcome. By the way, it's worth noting, Phil, so when we asked the courts to review the case and take the case up, how many states did we have? We had like, was it 26?
47.
Was it 47? Bipartisan states, and we're talking the most liberal to the most conservative, because people, or the parties I should say, want to have a fair set of rules and don't want the idea that a couple unelected folks can throw the whole system into upheaval. And then we had quite a few amicus briefs going into the actual hearing. I think most of them, a lot of them were very supportive of our position.
Well, thank you for that that information and that answer. We've got more questions coming in. One to either of you. Do you think the court will engage with the substance of the case and rule on the merits, or do you think that they will dismiss on the question of standing?
So for those non-lawyers out there, I want to explain. Standing means you as an individual don't have a right to bring an action because it doesn't actually affect you in what would be referred to by lawyers as a legally cognizable injury, which is a lot to swallow. Our argument is that if you're an elector in Colorado, it's not a paid position, so you don't have standing based on losing payment. It's not something where you're doing anything other than exercising an official function that is guided by state law. So you might not like what you have to do, but you signed up to do something that's being, under state law. You don't then have the right to say you think it's unconstitutional. You don't have standing. The problem for the court is the Washington case was a fine. It wasn't a removal. And so having to pay a fine gives you standing. So the court has to get to the merits. It's possible they could rule in our case on standing, but they're going to have to get to the merits in the Washington case. So more likely, they deal with the merits in the Washington case, and in our case, they just then say, we don't reach standing because in any event, there's no claim on the merits. That would be my prediction, but it's an interesting question, and we'll find out.
Thank you for talking us through that issue. Another question, if the court rules against the state, would you support amending the selection process to ensure that electors match the result of the popular vote?
Jenna, you thought a lot about this. How'd you answer it?
So what is the question? So the electors match.
If we lose, is there anything we can do in the elector selection process to limit the risk that we are afraid of?
I think there's a couple things, and it's a conversation that we're still having, both the attorneys in my office and then working very closely with some of the representatives of the Attorney General's office. I think there's different tools depending on what circuit you're in. So for example, states maybe not in our circuit could say, okay, only attorneys can be presidential electors. And if you failed your oath to the state, we will remove your bar. You will no longer be able to practice law. I'm not sure if we could do that here in our circuit, but other states might be able to. We could, of course, what I was suggesting, make it a felony to bribe an elector. Make it very clear that you cannot bribe someone, and that as an elector, you're acting as a government official, so it's also illegal to take money or do anything unethical. And make that very clear if it's not already. And we have a theory of how that is already very clear, but we want to underline that we will prosecute any type of bad behavior. This is goes to the core of our nation. I do think, and we have been encouraging the parties to really think about their role, both at the national level with the RNC and the DNC. They are both very much aware of this case, and I believe tend to basically agree and are in a similar position, but they could amend their bylaws of how they select electors. So I do think there are several tools at our disposal, and hopefully we just won't have to come to this position. Though I do think it's still worthwhile to make sure it's very clear you're not allowed to bribe an elector, even if we can enforce state law. That piece of legislation wouldn't be as meaningful, but probably worth stating. What else would you add to that, Phil?
I think you've got a lot of creative solutions here. The short answer is if we lose, we need all the creative ideas we can, because it's a little like a pandemic. You don't worry about a constitutional crisis over a presidential election until it happens, and then you're like, oh my God, why don't we do more to avoid it? So we need all the good ideas to ensure elector accountability if we can't use the force of state law. And I'm open to all sorts of options. I'll be honest, I am not focused on that right now because I really do believe we've got this. But if we, God forbid, end up in that situation, we're going to have a lot of creative thinking that we need to do.
Well, thank you. Yes, hopefully it will not come to that, but definitely some interesting options and scenarios to think through. Another question coming from one of our members. What would happen if the winning presidential candidate were to die? In the Supreme Court case, are the states actually asking to bind the electors to the party of the winning presidential candidate as opposed to the person?
This is actually pretty easy. We have two issues that have come up. It's worth hitting them both. What happens if the person dies before the inauguration day? And then what happens if the person is incapacitated, they're not dead. The 20th Amendment governs death. The 24th Amendment governs incapacity. There are provisions in each of them to deal with it. The short answer is either in basically the long term or the whole time, the vice president becomes president pursuant to the 20th Amendment. And 24th Amendment, you have this mechanism to say the president's not able to exercise the authority, vice president handles that temporarily. And it's worth noting that we didn't have the 20th Amendment until 1933. So before 1933, this issue of presidential succession was very, very fraught and tentative. And a book I might recommend to people who are history buffs is called Accidental Presidents. It goes through every vice president who becomes president, noting in a few cases, we were close to having no line of succession.
These are the things you get to think about as Attorney General and sometimes as Secretary of State.
Oh, definitely some interesting scenarios in it. Sounds like a very interesting book recommendation as well. Let's see, another question for either of you. What is your view of the role of the Electoral College? Couldn't a case be made that the founders intended that a member of the Electoral College be able to vote however they want?
Well, that's exactly the case being made by the other side, and we happen to disagree. That's the whole theory of the opponents. What would you add on to that, Phil?
Yeah, that's their theory of the case.
Yeah.
And they have this Federalist paper by Alexander Hamilton that they'll cite, which is actually misleading because the Electoral College was a last-minute compromise. Hamilton offers his gloss in Federal 68, I think, after the fact, but that's not a true representation of what the Constitutional Convention was thinking.
All right, well, thank you for that question. I think that takes us through all of the questions in the chat box. If any of the participants have additional questions or points that you'd like to revisit with the Secretary or Attorney General, we'd encourage you to enter those in the chat box. Let's see. I think maybe we touched on this a bit. How does one become an elector? Another question that's been submitted. Secretary Griswold, I think you had touched on that question a little bit. If maybe you could speak a little bit more to that.
Sure. So someone becomes an elector because it's really dependent on the party. So the Republican Party in Colorado will directly appoint electors. That's the executive committee that does that. The Democrats do it a little different, and it's an open vote. By the way, as an aside, I really want everybody to know that when it comes to the appointment of electors and how the process works, our office and I work very closely with the parties through the entire election process. And we're gearing up for our election on June 30th, and we have a meeting with both party attorneys every other week. And as election issues arise, we're in constant communication. And I think that's really important because we want to make sure that each party and all their representatives have faith in our elections. So whether it's choosing electors or a problem that arises or a new rule that we issue, I think it's really important to have both parties at the table.
That's a great point. Thank you for emphasizing that. Well, that looks like about all the questions we have, unless people can trickle in with a last minute question here, type quickly, as our time is kind of coming upon the close of the hour here. And as we're kind of nearing our end point, I'd just like to invite both of you to, share any parting thoughts or, final remarks or words that you'd really like to leave us with.
I would say democracy is a team sport, and all of you being engaged, understanding what's going on, working to make sure we continue to be good stewards of our democracy is an incredible gift to our state. So I would just say, keep it up. Thank you for what you're doing.
I totally agree. First and foremost, I'd like to thank our Attorney General. He put a lot of time and effort into this case. It takes a lot of time to get the briefs perfect, and then of course prepare. And he did a really good job, and we should be very grateful for him for defending our democracy in this way. And I just also want to reiterate that I am so grateful for the League of Women Voters for all that you have done in Colorado, for all your support last year in our big democracy reform push, and for getting the state to where we are, because now, like last year, we led the largest democracy reform, and this year we're leading the expansion of mail ballots across the nation. And this wouldn't have been possible without all of your guys' work. So we just have to keep at it. We have a couple of elections coming up. Ballots are already out. In-person voting starts on the 22nd. The big election day is on the 30th, and then we'll gear up for November. We are very lucky in Colorado that in 2013, we passed those provisions to send every voter a mail ballot. And we are also very lucky to be in this position to help a lot of other states. And we're going to see the mass expansion of mail ballots this year, which is great. And then I would just say 2020 is here. Gear up for 2021. I have a big legislative agenda. Campaign finance reform. We're going to get it done. Cybersecurity. All of it's on the table. And I know you guys are great partners. So I'm just looking forward to 2021 also.
Well, we are very excited to hear that. That sounds fantastic. And, you know, we are, the League of Women Voters is a very big believer in democracy being a team sport. So, you know, we can't agree with that statement enough. And thank you both for being here. This is, you know, just such an interesting topic, such a unique situation, and, you know, just so timely given, you know, where we are with our election process right now. So thank you very much for your expertise and insights and your time tonight. And with that, I will turn it back to Tony.
Well, this is really fascinating. And I'm looking forward very much to working on campaign finance. That's been something that we've been working on and thinking about for years and years. And we'd like to make some greater inroads in that topic. So we're there.
Tony, I have an idea that you're going to love. We're developing it. We'll bring it to you in a couple of months. And it hopefully, as long as Phil's attorneys say it's good to go, and they said it's good to go, they like it, this is going to be really big. And campaign finance reform is about stopping corruption, fighting corruption. Right. So there's your teaser, but I'm getting really excited about it.
Yeah. Oh, great. Very good to hear. So thanks very much, Secretary of State Griswold and Attorney General Weiser, for this forum on the faithless electors. The League intends to hold a series of these forums with both the Attorney General and the Secretary of State on a variety of topics. So just watch for the announcements of our next forum, and we trust we will see you again. Let me say, though, also that if you are not already a member of the League of Women Voters, you can go to lwvcolorado.org and find the league closest to you. We have about 19 leagues across the state of Colorado, and I'm sure one of them would love to have you as a member. So contact the league nearest to you. So good night, everyone, and be safe.
Good night.
Good night, everyone. Thank you.
Thank you. Good night.